If you are a green card holder or even planning to become one, what you are about to hear could directly affect your legal status in the United States, your ability to travel freely, and your entire future path to citizenship. This is not a rumor. This is not a proposal sitting in committee. And this is not something that might happen later this year. A new U.S. immigration law was officially passed today, and it quietly changes rules that millions of green card holders have relied on for years without ever realizing those rules could change. Some of these changes take effect far sooner than most people expect, and one of them can resurface decisions you made years ago, even if you believed you were fully compliant at the time. Staying with this until the end could mean the difference between protecting your green card and walking straight into avoidable problems simply because you did not know the rules had shifted. A green card is more than a piece of plastic. It represents the legal right to live and work permanently in the United States. For many people, it represents years of effort, sacrifice, and patience. But here is the part most green card holders are never clearly told. Permanent residence does not mean permanent freedom from oversight. U.S. immigration law is not frozen in time. It evolves with policy priorities, enforcement strategies, and technology. And when it evolves, the obligations attached to your green card evolve with it. For decades, many requirements were informal, lightly enforced, or only reviewed when someone applied for citizenship or traveled for extended periods. That era is now ending. The law that passed today reflects a much broader shift in how the U.S. government expects permanent residents to prove, document, and actively maintain their status on an ongoing basis. This is not about creating panic. It is about understanding that the rules you thought you knew may no longer be enough. In the next few minutes, we are going to walk through exactly what changed, why this law is different from anything we have seen in years, and what you need to do right now to stay protected before ignorance becomes the biggest risk of all. Today's update matters because the law that just passed is not a routine adjustment or a technical footnote buried in policy language. It represents a structural shift in how green card holders are expected to interact with the U.S. immigration system. And before you assume this is just another announcement that will not affect your daily life, understand this. What changed today directly alters long-standing assumptions that millions of permanent residents have relied on for years without realizing those assumptions were never guaranteed. So why is this January 2026 law fundamentally different from previous immigration updates? There are three reasons, and missing even one of them could create serious problems later. First, it changes compliance expectations that had remained largely unchanged for decades. In the past, many green card obligations were passive. You lived in the U.S., avoided major legal trouble, updated your address if you moved, and everything else was typically reviewed only when you applied for citizenship or traveled for extended periods. That passive approach is now gone. Second, this law formally introduces new verification and screening systems tied to travel and residency that were previously informal or inconsistently applied. What used to be handled case by case is now written directly into law, which means officer discretion is replaced by standardized review. Third, and this is the part that surprised even experienced immigration attorneys, the law expands how far back the government can look when evaluating your compliance history, even if you believed older actions were already settled or completely irrelevant. All of this is happening within a much larger immigration environment focused on what policymakers are calling status integrity. In simple terms, that means the government wants immigration statuses to reflect real-world behavior at all times, not just at the moment you apply for a benefit. If you are a permanent resident, the expectation is that the United States is genuinely your primary home. And that expectation now comes with clearer documentation and verification requirements. The margin for being uninformed has shrunk dramatically. The first major change, mandatory 24-month verification. The first major change affects every green card holder, no matter how long you have lived in the United States or how carefully you followed the old rules. Under the new law, green card holders will now be required to actively verify their permanent resident status through a federal system every 24 months. This is completely new. Until now, most people only interacted with USCIS when renewing a card, updating an address, traveling abroad for long periods, or applying for citizenship. Going forward, you will receive an official notice by mail, email, or both, asking you to confirm basic but critical information, including your current address, employment situation, and confirmation that you have not abandoned U.S. residency. The process itself is expected to take only a short amount of time online. But here is the key point. This verification is mandatory. Ignoring it is not a harmless oversight. Failing to respond within the required window can trigger a formal status review. That does not mean you lose your green card instantly, but it does mean your case moves out of the background and into active scrutiny. Consider someone who received their green card a few years ago, built a life in the US, and rarely thought about immigration paperwork again. Under the old system, that approach worked. Under the new law, when that verification notice arrives, there is no flexibility to delay, ignore, or assume it does not apply. USCIS has made clear that this process is designed to confirm continued ties to the United States, not to catch people by surprise. But the responsibility now sits squarely on the green card holder to respond on time. The second major change, stricter travel scrutiny. The second major change is where many green card holders are feeling the most anxiety, and it involves international travel. Under the new law, any green card holder who spends more than 180 days outside the United States within a 12-month period will now be subject to enhanced screening upon return. This does not automatically mean denial of entry, but it does mean you should expect additional questioning and much closer examination of your ties to the U.S. In the past, long absences raised concerns, but enforcement was inconsistent and often depended on the individual officer you encountered at the port of entry. Now, that scrutiny is standardized. If you cross that 6-month threshold, you must be prepared to clearly demonstrate that the United States remains your primary residence. That includes evidence of ongoing employment, housing, tax filings, family connections, and clear intent to return. For people who travel for work, family obligations, or extended emergencies, this change does not ban travel, but it demands preparation. Walking into a U.S. port of entry without documentation after a long absence is no longer a risk worth taking. The third major change, annual reporting for certain green card holders. Another major change introduced by this law applies to specific categories of permanent residents. Under the updated rules, certain green card holders will now be required to submit brief annual reports confirming that the conditions under which their card was originally granted still exist. This applies primarily to employment-based green card holders, investors who obtained permanent residence through programs like EB-5, and individuals with conditional permanent resident status, such as those who received a green card through marriage and are still within the conditional period. These reports are completely separate from your tax filings and separate from the new 24-month verification process. The purpose, according to lawmakers, is to ensure that green cards issued through specific pathways are being used as intended, and that key qualifying conditions have not quietly disappeared. For most people, the report will be straightforward, but failing to submit it can create delays, trigger additional review, or raise serious questions later when applying for citizenship. Silence is no longer neutral. It can be interpreted as non-compliance. The fourth major change, expanded review for citizenship applicants. One of the most unexpected and controversial parts of this law affects people who are applying, or plan to apply, for U.S. citizenship. In the past, when USCIS reviewed a naturalization application, they focused primarily on the 3-year or 5-year period immediately before the application was filed. Under the new law, USCIS is now authorized to review your entire period of permanent residence when evaluating continuous residence and physical presence. That means travel patterns, extended absences, and compliance issues from years ago can now be re-examined, even if you believe they were already settled or irrelevant. For someone who received a green card 8 or 10 years ago and is only now applying for citizenship, decisions made early in your permanent residence may now carry more weight than ever before. This is one of the reasons immigration attorneys were caught off guard, and it is exactly why preparation and documentation have become critical at every stage, not just at the end. Separating fear from reality. It is important to separate fear from reality because misinformation spreads fastest when anxiety is high. One common fear is that any international travel will now put your green card at risk. The reality is that travel is still fully allowed. Long absences simply demand better preparation and clearer proof of your U.S. ties. Another fear is that missing a verification deadline means immediate loss of status. In reality, a missed verification triggers a review process, not instant deportation. USCIS has stated there will be multiple notices and ample opportunity to comply before any serious action is taken. There is also concern that this law targets specific nationalities. That is not the case. The law applies uniformly to all green card holders, regardless of national origin. The real shift here is accountability. If you live in the United States, maintain genuine ties, pay taxes, and treat your green card as a responsibility rather than a formality, this law is not designed to punish you. The risk comes from ignorance, and understanding that distinction is critical. What you should do right now. Start by making sure you are relying only on official information, not social media rumors or online forums where misinformation spreads fast. USCIS and the Department of Homeland Security will be releasing updates as the new systems roll out, and those updates matter. Next, confirm that your address on file with USCIS is current. Missing a notice due to an outdated address is one of the easiest ways to create unnecessary problems. Review your green card expiration date. Review any upcoming international travel plans. Begin building a simple travel log that records when you leave the United States, when you return, and why you traveled. Then start organizing documents that prove your ties to the U.S., housing records, employment verification, tax filings, bank accounts, and family connections. Keep both digital and physical copies. For anyone with a complicated travel history, extended time abroad, or upcoming naturalization plans, speaking with an immigration attorney now can bring clarity and peace of mind. Preparation today is far easier than damage control later. Bringing it all together. Today, January 23, 2026, a new U.S. immigration law passed that changes how green card holders are expected to maintain and prove their permanent resident status. The core changes are now clear. Mandatory verification every 24 months, stricter scrutiny for extended international travel, new annual reporting requirements for certain categories of permanent residents, and expanded review of your entire green card history when applying for citizenship. These are not minor paperwork updates. They are structural changes that shift permanent residence from something passive into something that requires ongoing awareness and responsibility. But here is the most important thing to understand. This law is not designed to punish people who genuinely live in the United States and treat it as their home. If you work here, pay taxes here, maintain real ties, and respond when asked, you are not the target of this law. What you should feel right now is not panic, but awareness. Awareness that the rules have evolved. Awareness that staying informed and organized is now part of protecting your future. And awareness that ignoring these changes carries far more risk than the changes themselves. Millions of green card holders will navigate this new system successfully, not because they are perfect, but because they stay informed, respond on time, and take their responsibilities seriously. You can be one of them. If this helped you understand what just passed and why it matters, share it with anyone you know who holds a green card. Right now, ignorance is the biggest vulnerability. Leave a comment below with your questions or concerns, and we will continue breaking down updates as USCIS releases implementation details and real-world guidance. Your green card represents opportunity, stability, and your future in the United States. Protecting it does not require perfection. It requires awareness, preparation, and action. Stay informed, stay compliant, and stay protected.